Ladies and gentlemen, I know some of you are either finishing up your entree or have been to the dessert bar or are wanting to go to the dessert bar. But I want to get us started now because our featured speaker, our keynote luncheon speaker today, has a flight back to Washington, and he's going to be picked up at 2 o'clock. So bad things happen if I don't get us going on time. Our Friday luncheon speaker is the Honorable Robert S. Litt, who was confirmed by the Senate last June to become the second General Counsel of the Office of the Director of National Intelligence, Admiral Blair. He holds a bachelor's degree from Harvard College and both a master's degree and a JD from Yale. Following law school, Bob clerked for Judge Edward Weinfeld of the Southern District of New York and then for Justice Potter Stewart of the United States Supreme Court. From 1978 until 1984, he was an assistant United States attorney for the Southern District of New York and also spent 1 year as a special advisor to the Assistant Secretary of State for European and Canadian Affairs. From 1993 until 1999, Mr. Litt was at the Department of Justice, where he served as Deputy Assistant Attorney General in the Criminal Division, and then as the Principal Associate Deputy Attorney General, where he worked on FISA applications, Foreign Intelligence Surveillance Act applications, covert action reviews, computer security, and other national security affairs. Before joining the office of the ODNI, Bob was in private practice as a partner at Arnold & Porter in Washington. He served as a member of the governing body of the American Bar Association's Criminal Justice Section, as well as a member of the advisory committee to the ABA's Standing Committee on Law and National Security, where I see him quite frequently up in Washington at the meetings. It's a real privilege and pleasure to welcome the Honorable Robert S. Litt to Duke and to our conference. So Bob, over to you.
Unlike Jay, I do have prepared remarks. I don't trust myself. I do want to thank Scott and the Center for inviting me here today. This is, of course, one of the premier conferences in the area of national security law, and it's an honor to be invited to speak here. To quote a famous British philosopher, and now for something completely different. You've had a number of panels on really interesting topics over the last 2 days, many of which occupy a lot of time of lawyers in the administration. And I want to echo what Jay said yesterday about the sheer intellectual joy of dealing with the lawyers who are working in this administration, who are a phenomenally smart, experienced, and collegial group. And there's just no greater pleasure than going down and sitting around a room in the White House and arguing about these things. But the administration's policies on all of the issues that we have been talking about and that you will talk about this afternoon rest upon a foundation of good intelligence, which we need to make sure that the decisions the policymakers make are founded on the best possible information. And I would like to talk a little bit today about how we're trying to ensure that that happens, and of the role in particular played by my somewhat obscure office, the Office of the Director of National Intelligence. April 21st will mark the 5th anniversary of the stand-up of the ODNI. It was created by Congress, which determined that integrating and unifying the intelligence community under a single leader was the best way to ensure that the policymakers and the war fighters and everyone else who needs it gets timely, objective, and independent intelligence. The idea that there should be one single central figure on top of the whole intelligence community was not new. In fact, discussion of this idea began shortly after the passage of the National Security Act in 1947. Just 2 years after creation of the CIA, in 1949, the first Hoover Commission, which I'm reliably told existed, although I do not remember it, commented on the lack of coordination and information sharing among agencies in the executive branch. And in 1955, the second Hoover Commission recommended that the Director of Central Intelligence, the DCI, have a deputy who could run the CIA while the DCI devoted himself to managing the intelligence community. Over the next 5 decades, there were a number of refinements to the way the intelligence community was structured and operated, some of them relatively significant. But none of them was really of the scale and scope of what happened in 2004 with the enactment of the lengthily named Intelligence Reform and Terrorism Prevention Act, or IRTPA, which is what founded the ODNI. And this was prompted by the intelligence failures that were identified by the 9/11 Commission. And again, as I said, the fundamental idea was that if we integrate and coordinate the intelligence community, if we take advantage of economies of scale, if we eliminate redundancies, and we accomplish greater information sharing, we can make the national security apparatus more effective. Now, none of this is really new to you, I imagine. Talk about integration of the intelligence community and connecting the dots and so on is pretty much a platitude these days. What I would like to do over the next few minutes is focus a little bit on what this means in actual practice. While the IRTPA really affected in some respects the entire intelligence community and everything it does, I'd like to view this through the lens of the concept of information sharing. This is, of course, a hot topic in the wake of the attacks at Fort Hood and the failed attack on Northwest Airlines Flight 253. And so hopefully it'll provide a useful and comprehensible framework to talk about information sharing. So I want to begin with the statute. IRTPA says that the DNI, quote, shall have principal authority to ensure maximum availability of and access to intelligence information within the intelligence community, subject to national security requirements. That's straight out of the recommendations of the 9/11 Commission. So what has the DNI done to try to accomplish this? From a legal point of view, the most important has been the promulgation of Intelligence Community Directive 501 in January 2009. An ICD, an Intelligence Community Directive, is a way of giving policy guidance to the intelligence community. An ICD 501, which is entitled Discovery and Dissemination or Retrieval of Information, mandates wide-ranging information sharing activities, including the ability for intelligence analysts, wherever they're located in the community, to discover and request information from any other element of the intelligence community, and imposes on those other elements a responsibility to provide such information. The ICD also sets up a dispute resolution and appeal mechanism whose purpose is to balance the requirement for information sharing with the DNI's responsibility, which he also has by statute, to protect sources and methods. The goal, again, is to enable analysts to find the information that's out there that's relevant to them and to retrieve it. And if any of you has an additional interest in this, ICD 501, like all other classified policy guidance issued by the ODNI, is available on the ODNI website. I don't have a flashing light behind me. Now, this idea that intelligence information should be widely discoverable and retrievable sounds pretty obvious and straightforward. In fact, the mere creation of ICD 501 was a very time-consuming process that involved lengthy interagency deliberations. And full implementation of ICD 501 is more difficult yet. It faces a number of legal, starting with the legal obstacles. One of the biggest obstacles is found within IRTPA itself. Anybody who knows anything about IRTPA knows that it was a series of compromises among congressional committees, among elements of the U.S. government, and between privacy advocates and advocates for greater security. If a camel is a horse created by a committee, then the IRTPA is a whole caravan. It's rife with inconsistencies and ambiguities. Some kinds of aspects of the ambiguity were addressed in 2008 when Executive Order 12333, which is the foundational document of the intelligence community, was rewritten. But not all of them. There's still substantial remaining ambiguity. Let me give you a specific example of how this ambiguity plays out in the context of information sharing. As I mentioned, the DNI has the statutory mandate to ensure broad information sharing, and as part of that, he is empowered to set common IT standards across the intelligence community. But as many of you know, one of the big questions when the IRTPA was passed was how much authority do we give the DNI? At one poll, you have the idea of a Secretary of Intelligence. This was something that was advocated by former DNI Mike McConnell in a speech he gave last week. At the other poll, you have a sort of relatively weak a person whose only job is to coordinate what is in effect a federation of independent fiefdoms. And this is the key compromise that was created when IRTPA was enacted. It's pretty clear that Congress did not enact either extreme. It did not create a Department of Intelligence where each element of the intelligence community reports to the DNI in the same way that the civil division of the Department of Justice reports to the Attorney General. On the other hand, it's also pretty clear that they created something more than a mere facilitator of agreements among independent agencies. The statute gives the DNI a huge to-do list. There's something like 280 separate statutory mandates on him in areas relating to budgeting, personnel, acquisition, intelligence collection, security clearance reform. And to accomplish these tasks, the DNI has to have some degree of authority to direct intelligence community agencies and not just bed them. So his authority falls somewhere between the two extremes, but exactly where between those two extremes it falls is very unclear. And the water is further muddied by a specific provision in IRTPA, which was inserted according to press reports at the instance of then Secretary of Defense Donald Rumsfeld, which is Section 1018 of IRTPA, which provides that the President shall issue guidelines to ensure the effective implementation and execution within the executive branch of the authorities granted to the Director of National Intelligence in a manner that respects and does not abrogate the statutory responsibilities of the heads of the departments of the United States government. So if you think about this, it's pretty easy to see how this provision, if you read it expansively, could essentially eviscerate the entire authority of the DNI. And I think I'm not talking entirely out of school to say that that has occasionally been advocated by the heads of some departments within the United States government. But as we read it in the ODNI, there are several limitations on this provision. The first is that it applies only to the heads of departments. It does not apply to the heads of agencies within the department. So while the Secretary of Defense or the Attorney General can play this trump card, the Director of NSA or the Director of the FBI cannot. Secondly, the word abrogate, according to Merriam-Webster, means to abolish by authoritative action or to treat as non-existent. That's a pretty strong word. In our view, it's not enough that the DNI exercises authority to push at the margins of the authority of a department head or to limit those authorities in some way. Rather, he has to exercise his authority in a way that actually abolishes that department's head's authority in that area. At least, as I said, that's how we read it. But at a minimum, Section 1018 creates an opportunity for conflict and argument. So the statutory ambiguities in the DNI's responsibilities are only part of the legal problems. And I will circle back to the information sharing question, but I want to lay out all the legal framework at this point. There are practical limitations created by the statutory authorities. For example, the DNI has authority under IRTPA to transfer and reprogram funds to address intelligence community priorities. But he can't do this just by signing a piece of paper. He has to consult with the affected agencies. And he has to notify Congress. So again, there are limitations on what he can do. And the DNI's authorities often overlap with those of other agencies. To give you one example, while the DNI has authority to set up a joint duty program to require people to serve in other agencies before they get promoted to senior level, there's another provision that says the Secretary of Defense, notwithstanding any other provision of law, has the authority to appoint persons to senior positions. So again, there's a statutory conflict there. And finally, there are executive orders such as EO 12333 that also flesh out the DNI's authorities in ways that sometimes create more complexities. For example, there's an entirely separate provision in EO 12333 for how signals intelligence has to be shared. It's governed by a different set of rules. Because of all of these ambiguities and overlapping issues, the role of the ODNI and of the DNI is defined as much by the actions of the President, the individual DNI, and the heads of the IC elements in their parent agencies as it is by the words of the statute. And this is one of the important points I want to make today. The structure of the intelligence community going forward is going to be developed as much by an essentially political process of flexibility and accommodation among government agencies as it is by a kind of quasi-judicial process of interpretation of a statute. So now at last, let me circle back to the issue of the DNI's authority to set IT standards to ensure information standards. I think you can see how some of these ambiguities are going to play out and create carrying out that responsibility difficult. For example, the DNI can say, we need this kind of IT system to best further information sharing across the community. There's a wide variety of databases and systems, and we need to have them talk to each other. But does he have the power to compel individual agencies to adopt that system? That's not clear in the statute. And apart from this process of accommodation and consultation, you really can't get the job done. And these impediments are even more pronounced when you think about information sharing, not only within the elements of the intelligence community, but also with executive branch departments that are not part of the intelligence community, with state and local authorities, or with, from private companies or foreign sources. With respect to non-intelligence federal agencies, the DNI has authority to have access to all relevant information that they have, except as otherwise provided by law. Well, that except as otherwise provided by law provision is going to create challenges. What do you do, for example, with HIPAA that protects personal medical information? This is obviously a very important privacy protection, but at the same time, a strict application of HIPAA might prevent or hinder the ability of the intelligence community to gain information that may be critical in dealing with a bioterrorism attack or even a pandemic. State and local authorities can be a very important force multiplier in dealing with terrorism. And so we want to be able to share information with them as well. But doing so may present challenges under state privacy laws or state sunshine laws, and also obviously creates challenges for protecting the security of information. Private companies are often willing to provide information to one agency of the United States government, but they may want to impose restrictions on how that information can be used within the government. This is a problem that I've recently encountered in a specific context. And finally, foreign nations, as we know, often require limitations on what we can do with information about their citizens. All of these different restrictions make the process of sharing information immensely complex. Finally, there are also a series of policies within the United States government that add another layer of complexity. The best known of these are what are known as the U.S. Person Rules. Under Executive Order 12333, each agency of the intelligence community has to have guidelines approved by the Attorney General that govern the collection, retention, and dissemination of information about United States persons. And the purpose of these is obviously to ensure that we are not improperly spying on Americans. And while the language used in these rules is often broadly similar, there are some differences between agencies, and even more so, there are differences of interpretation between agencies, so that you may have one agency's U.S. persons rules looking somewhat different from another agency's U.S. persons rules. Some of these differences may be warranted by differences in the missions of the individual agencies, but right now one of the things we're trying to do with the ODNI is get agencies together with the Department of Justice and see the extent to which we can harmonize these rules for the purpose of facilitating information sharing. So there are a whole bunch of legal and policy challenges to full information sharing that we're trying to work out. But once the lawyers stop debating the legal and policy issues, we get to the technical challenges. Because full information sharing requires more than just revisions to our policies. It's going to require, as I mentioned earlier, an extensive investment in infrastructure to ensure, to give you one example, that if you have an analyst at DHS who's looking at a domestic radical who's got some contacts with foreign persons, that this analyst at DHS has the ability to reach out to CIA and find out what CIA knows about those foreign contacts. That's the kind of information sharing that ICD 501 mandates. And in the highly networked environment that we have today, you'd think that this would be easy enough, but in practice it's very hard. Again, the statute, as I mentioned earlier, gives the DNI the authority to establish common technology standards, protocols, and interfaces, and to have procurement authority over all enterprise architecture-related information within the that is funded by the National Intelligence Program. And parenthetically, enterprise architecture is not a word that I would have used before a year ago. And it makes sense to give the DNI this authority because if you can develop interoperable systems, it's going to be key to efficient sharing of information and full all-source analysis. But remember that including the ODNI, there are 17 separate elements of the intelligence community. And I can actually name them for you now if you want. But 15 of those elements are housed in 6 different executive departments, the State Department, Defense Department, and so on. And indeed, for many of these departments, intelligence is a very small part of their overall mission. Should these 15 elements of the intelligence community, should their IT systems be part of the intelligence community enterprise architecture or that of their home agency? To return to the example I gave a minute ago, should the Department of Homeland Security's Office of Intelligence and Analysis, which is part of the IC, should they use the same IT structure as the CIA does? If they did, then that would really enable the two agencies to talk to each other very easily. But then INA might not be able to talk to Customs and Border Patrol or other aspects of Homeland Security that are not part of the intelligence community and have the DHS intelligence system. So this is a really difficult issue to solve. And in addition to that, any technical solutions that we devise are going to have to take account of the increased security risks that will come from broader sharing of information. Sources and methods is one of those phrases that is incanted so frequently by the intelligence community that people sometimes forget that it actually has real content to it. If we cannot protect the people who provide us intelligence, we can't protect our sources. If we can't protect the technical means by which we get intelligence, we won't be able to get intelligence. And the more people who know sensitive information, the more the risk of unauthorized use or unauthorized disclosure increases. On the other hand, the risk of compromise has to be balanced against the risk of not sharing information, the risk that a failure to share information could lead to another 9/11 or worse. And this is one of the central problems that the DNI has to deal with. Now, there may well be technical solutions that help us deal with these problems. We may be able to devise agents that can look across incompatible systems. We may be able to set up comprehensive audit trails that help protect security. We may be able to strip out certain particularly sensitive information from intelligence as it's shared. But there may be other fixes. Navigating IT issues is pretty much beyond my capability these days. That's why we have children. But I think you understand that this is hard stuff and it's not going to be solved overnight. Finally, as I mentioned, there is also a set of cultural challenges to information sharing. There's a natural tension between the collection agencies who want to protect their information and the users of intelligence who want access to the information. The 9/11 Commission's report noted that even the best information technology will not approve information sharing so long as the intelligence agency's personnel and security systems reward protecting information rather than disseminating it. And so no matter how accommodating our legal rules are, no matter how flexible our systems are, information sharing won't work unless people want to share information instead of hoarding it. And that's why ICD 501 sort of reversed the fundamental premise of the intelligence community, which was that information was only shared on a need-to-know basis, and imposed essentially a duty to provide information. We've made a lot of progress in changing the culture, but we're not there yet. Many elements of the intelligence community have a natural desire to protect their crown jewels, the CIA's most sensitive human sources or the NSA's coolest tricks. And this derives in part from a desire to protect the sources and methods. It's hard to change people's attitudes in this regard, and we still see this attitude surface. But Congress and the President have both determined that the balance between security and information at this point has to be tilted in favor of sharing information, and the culture of the intelligence community has to catch up. In my view, that won't happen except over time with sort of a demonstrated series of successes that show, number one, the benefits of information sharing, and number two, that we can accomplish information sharing without undue risk. Finally, I want to talk a little bit about where we're going in the future. First, even the best and most comprehensive sharing of information is not going to be enough to protect the nation and to provide full information to policymakers. The fact that we couldn't stop Umar Farouk Abdulmutallab from getting on that plane shows that. Both the President and the DNI and others, such as Senator Lieberman, have noted that this was not a failure of information sharing. The relevant information was shared. Rather, it was a failure to recognize and connect and evaluate the information that we had shared. Each day, the National Counterterrorism Center, which is part of the ODNI, a critical part of it, receives literally tens of thousands of pieces of intelligence information from around the world. It reviews thousands of different names of individuals. It places hundreds of more individuals in its databases. It's easy to find the right piece of the puzzle when you know what you're looking for, but it's a lot more difficult to find the right piece of the puzzle when you don't know what you're looking for, and it may be mixed up with pieces of hundreds of other puzzles. The challenge for the intelligence community is not only to collect the data and share it, but to develop the capacity to analyze it, identify it, and interpret it in ways that are meaningful. And so from an IT point of view, we have to focus not only on information sharing, but on sharing information in a way that helps us sort out the information. This is an enormous technical challenge that's going to require, I think, very sophisticated uses of artificial intelligence, given the volume of information that we're getting. But I also want to make it very clear, although I think that most of the people in this room understand it, no matter how well we share and analyze information, the intelligence community cannot provide the United States immunity from attack. We face a committed, determined, and creative enemy who learns from his past failures and adapts his tactics. Even with the best technical and organizational solutions, we are never going to be 100% safe. But that's not necessarily going to represent a failure of intelligence. If you look back at World War II, our forces were attacked pretty frequently then, but nobody suggested that each such attack resulted from a failure of intelligence. Secondly, and I think this is a point that was discussed a little bit at yesterday's panel on cybersecurity, I think the intelligence community is going to have to adapt to an environment in which it is increasingly difficult to protect secrets. The same information technology that facilitates information sharing is vulnerable to network attacks. A more open intelligence community creates more opportunities for recruitment by our enemies. Information once stolen can be posted on the internet and go viral in a few seconds. The same biometric technology that may help us identify terrorists may also make it difficult or impossible for us to have people travel undercover. In my view, we're not only going to have to adapt our systems to try to protect classified information in this increasingly challenging environment, but we are going to have to confront the implications of a growing inability to protect information at all. And how does an intelligence community operate in that sort of environment? So, to sum up, the IRTPA and the structures it created are sort of the public face of intelligence reform. But the actual work of carrying them out is a much more complex process that involves executive orders, policy statements by the DNI, coordination and oversight, and most fundamentally the hard work of individual members of the intelligence community operating to try to work together. In my personal view, to go back to the question of the authorities of the DNI, this requires that the DNI have a strong set of authorities to be a strong leader who can establish goals and policies for the community and then make them happen. But under any circumstances, the DNI is going to have to do this through this political process of working with the heads of the departments and the elements of the intelligence community. And so it's very much going to be a process driven by personalities and the individuals who are operating those, occupying those positions. Finally, I want to emphasize that we are still at the beginning of intelligence reform. In the past 5 years, the intelligence community has made great strides, but we have a long way left to travel. And if you think about the integration of the military, which started, I guess, in 1947 with the creation of the Joint Chiefs, and is still not wholly accomplished today. Just last month, I guess, there was an article in the Washington Post which said that the Marines in Afghanistan were perceived by the Joint Command there as operating independently. Now, I know you have to discount a little bit because it's Marines, but still in all. Nobody should be surprised if 5 years out the intelligence community hasn't gotten there yet. I'd like to think, however, that in 5 or 10 or 15 years at this conference, my successor, whoever he or she may be, will be able to address you and describe a more fully integrated, coherent intelligence community whose employees think of themselves first as members of an intelligence community and then second as members of an individual agency within that community, because I think that's the best way that the intelligence community will be able to operate in defense of the nation. Thanks, and if I'll entertain questions. I'll entertain questions not only on this dry topic, but on other topics.
Except for when you discussed the compromises made, you made no mention of the concerns of privacy advocates for this. I agree with you completely about the challenges of analysis once information sharing is achieved and the need to move in that direction. Yet the most prominent example of that in the post 9/11 era was Poindexter's efforts in the Department of Defense, which, for a host of reasons, but not the least of which was significant privacy concerns, absolutely fell apart. Softball question: tell us what you're going to, how you are going to ameliorate the privacy concerns that must attend any enhanced information sharing and analysis with it.
I think that the problem with the total information awareness that was proposed in the Bush administration was less the concept of sharing information within the intelligence community and more the fact that this was perceived as an occasion for vast data mining of other information out there, public source information. What I'm talking about within the framework of this context is simply sharing the information that the intelligence community is authorized to collect, and ensuring that everybody within the intelligence community has the broadest possible access to information that we're allowed to collect. What we're allowed to collect is a different speech, you know, there are a lot of interesting issues in that regard, but that's a separate issue. And so to the privacy advocates, and my comment is you should not have a concern with how we share it within the community. Your concern should be, are we allowed to get it? And what do we do with it once we do it?
My question builds on Paul's. Have you prepared a written opinion describing how ICD 501 is consistent with requirements of the Privacy Act, HIPAA, these other statutes? And if you have, would you be willing to share that with us? And can you tell us why ICD 501 is classified?
It's not classified. ICD 501 is not.
That's the easy part. ICD 501 was actually, it was promulgated before I got on the job. If there was a formal written opinion, I don't know. Having said that, though, I sort of reiterate the point I made to Paul. Each agency within the community has its set of rules under the Privacy Act, the systems of records, notices, and so on. HIPAA is much more of an issue of what we're entitled to collect. All that ICD 501 does is say, if the CIA is lawfully entitled to collect information, then the FBI, the analysts at FBI, the analysts at DHS, the analysts at NCTC should be able to get that information in the easiest possible way and with the maximum possible transparency. So I don't think it has that broad an impact on privacy. I think that this would probably fall within most routine use exceptions.
Another question?
I think you had said early on that the only way that you get information is by requesting it of another agency. Is that correct?
You mean under ICD 501? It's a two-step.
The agency has to make the information determined is discoverable. In other words, you have to be able, I as an analyst in CIA have to be able to discover that NSA has information about this topic. And then if it's relevant to my mission, I can request it from them.
Okay, but how do you know what is relevant for information that you want to request if they don't have to voluntarily give it to you?
Well, the theory is that they have to put it out there with enough information so that if I'm working on, to pick a random example, Nigerians who may be being radicalized, that I know that there's something out there that's relevant to me. And obviously, you know, analysts sweep pretty broadly because they'd rather sweep a little more information in that is not relevant to them and discard it than miss something that is relevant. That part of it is on the analyst to know what's relevant to him.
As I recall, the 911 Commission considered this recommendation of creating DNI, centralizing, coordinating, to be just crucial to trying to prevent another 911 or something like that. And then it went through the meat grinder in Congress, and then it went into the battlefields within the executive agencies. Do you have any assessment at this point, personal assessment, of the extent to which this structure now and its projected progression meets the objectives of the 911 Commission? I think it's way short, or is it on the mark?
Go and lie answer here and say it's too soon to tell. I can tell you that Lee Hamilton and Thomas Kane, who were the two chairs of the 9/11 Commission, do not think that the current structure of the DNI, of the ODNI, meets what they had in mind. I can also tell you that there are individuals who believe that the ODNI has too much authority, that it's simply a bureaucratic layer that creates requirements that interfere with the actual carrying out of intelligence. As I said, in my view, I think we're going to have to watch how this plays out and see whether the DNI actually has the practical authority to impose integration on the community or not. And so, to that extent, my kind of flippant reference to Joe and Lai's comment is actually true. We're still pretty early in the process.
We have time for one more question.
Expect to be able to take not you necessarily, but take responsibility for not passing on the information of the Nigerian bomb. In other words, everybody said, well, you failed to share. But
It wasn't a failure to share.
Case, it was all there, but people didn't either didn't or weren't able to put it together. I mean, for example, the State Department had the information, but they spelled the guy's name wrong when they typed it in. So, the information was shared, but what wasn't there was the ability to focus on it and identify it. And if people had taken certain steps in terms of how they analyzed it, they would have been able to pick this up because the information was all there.
But wouldn't we expect to be able to do that so that somebody could say it's their fault?
Right, and one of the things, the president directed that the intelligence community look at how it did this, and there's a pretty vigorous effort right now on to try to increase our ability to analyze information and also to identify what sorts of information we need to be looking for. I think that's definitely one of the follow-ons from that event.
I'm going to go ahead and conclude this luncheon because I know Bob's got to be picked up and make an airplane back to Washington just like Jay did yesterday. But Bob, thank you so much for coming down for a whole time.
My life was in the
I've looked at the
I asked him, he said it is.
Yeah, every time I give a gift to the speaker, they need to know I've checked the government and ethics rules before I give it to them and buy them. Anyway, we will be reconvening for our last panel. It's going to be on environmental changes and national security at 2:15 back in Janine. My guess is they have refreshed the afternoon snacks. So for all those who did not get enough here, there'll be some more over there. So we'll see you back in Janine Auditorium.